Good morning, good afternoon, and good evening, everyone, wherever you may be. Welcome and thank you for joining us for the second of three webinars sponsored by Mackrell International, Countdown to the GDPR, which is the short name for the General Data Protection Regulation. Mackrell International is a global network of 90 independent member law firms, totaling 4,500 lawyers working in 170 offices in 60 countries. Mackrell International delivers legal services to companies who need global expertise and local influence. Our speakers, Marta Stefanian, Henrik Nielsen, and I are all proud members of Mackrell International's Privacy and Data Security Group. Marta is a lawyer with Ten Holter Nordum in Rotterdam, the Netherlands. She counsels clients on all aspects of current and future Dutch and European privacy laws. Momentarily, she focuses on creating awareness and aiding companies in implementing the General Data Protection Regulation. For that purpose, she regularly publishes articles, organizes congresses, and provides workshops. Henrik is a lawyer with Westlaw Söderqvist in Stockholm, Sweden. He has more than 15 years' experience of commercial and regulatory law on areas such as IT, telecom, internet, and e-commerce. Henrik has worked at domestic and international law firms, at the Swedish Telecom and Competition Authorities, and at the Ministry of Communications. My name is Sean Tuma, and I will be moderating today. I am a cybersecurity and data privacy attorney at Sheaf & Stone, a mid-sized commercial law firm in Texas in the United States. As you explore the webinar platform, you will see there's an option for submitting questions. We will not be taking questions until the end of the webinar, if we have time to do so then, and we probably will not. However, in the event you have questions and we do have time, you may use the button that's in the middle of your screen up at the top for submitting questions. Hoag Fenton is providing the webinar platform and is also providing 1 hour of California General CLE credit for this webinar through the California State Bar. For those requesting CLE, please email gdpr@hoagfenton.com and we will provide you with a CLE certificate. A copy of the materials will be sent to all registrants following the webinar. The webinar is being recorded and will be made available to registrants through May 31st, 2018. Now let's get started.
Thank you, Sean. My name is Marta. Sean already introduced me. I'm going to start the webinar by addressing the most important question, which is, does the GDPR apply to me as a U.S. company? And the short answer is that in some cases it does. And if you have an establishment in the EU, regardless of where the processing is taking place, the GDPR applies to you. And if you do not have an establishment, the GDPR could still apply if you are processing personal data of data subjects who are in the European Union. And only in the cases where the processing activities are related to offering goods or services to those data subjects in the EU or monitoring the behavior of data subjects. Now, you could be monitoring the behavior of data subjects if, for example, you are the owner of an application being used in the EU that tracks location. You could be offering goods or services to the EU if you have a web shop which delivers products to the EU and who has a lot of EU customers. The third bullet point is probably not applicable to you, so we're just going to move forward to the next slide unless Henrik has something to add to this one.
Thank you, Marta. No, just want to underscore your point of the fact that if your organization has an establishment in the European Union, it'll be covered by jurisdiction even if the processing does not take place in the EU, just as it says in the slide. And I like the example of Google where the Spanish Data Protection Authority interceded against Google, even though the search service provided by Google was not carried out in Spain. But the fact that Google had a branch that sold advertising in Spain meant that the search carried out in the United States fell under the national jurisdiction. So this is something to remember, that even if your processing is far removed from the EU, it could still be covered. That's the point I felt important to elaborate. If we're moving
Exactly.
on
The
to
legal
the next
form
slide.
is not the determining factor.
Yes, exactly. Moving on to the next slide is the sort of bullet points summary of what are we going to be talking about during this webinar. This is the short list that once you've understood that your organization is liable to follow the GDPR, you could print out this slide and tape it to the wall at your desk. Because here is the most basic point of what you need to remember to do. One, first being to actually appoint a representative in the EU member state or member states where that will be affected by your processing if you're providing services to these member states or you have an establishment there. You need to check if you are required to have or if you really need a data protection officer appointed in your organization. You will most likely need to set up a record of the processing activities carried out. We highly recommend that you review the lawfulness of each processing activity being carried out. That is to say, determine what is the legal basis for the data processing being carried out. And we're going to discuss this more in the webinar. You need to review your present contract with your processors if you are engaging the services of a data processor. There are new formal requirements to the contents of these processor agreements. You will, in some cases, will be required to execute a formal data protection impact assessment if the processing you do is of that nature. Even if it's not a requirement, it will often be of very use to do a more of an informal, regulated impact assessment. Everybody will need to provide information to data subjects about their rights and about the processing being carried on. Your organization needs to be able to ensure that data subjects are able to exercise these rights. You will be required to set up a data breach policy. The GDPR introduces as a new measure explicit requirements to report any data breaches to mostly to the supervisory authority, but in some cases even the data subject whose data has been breached will have to be notified of this. We strongly recommend organizations to review and set up if you don't have a privacy policy. Just as you are reviewing the legal bases for your processing, one such thing to review is the basis for any international data transfer being carried on. If your organization is moving personal data from the EU to the US or even to other foreign jurisdictions outside the EU or EEA, there has to be a legal basis for this transfer. And finally, but not least, there's now an explicit legal requirement to make sure the data processing is done in a secure fashion. So this is the summary. This is the points we'll be talking about during this webinar. Now over to my colleague Marta to discuss the first such requirements.
So once you've assessed that the GDPR applies to you as a company, you will probably need to appoint a representative who will represent you in one of the member states. You need to designate a representative in writing and mandate him to act on your behalf and to be addressed on your behalf by the supervisory authorities or the data subjects. This could be in addition to or instead of addressing you. You do not have to appoint a representative if your processing is occasional. And if it is occasional and you are processing sensitive categories of data, so for example, you are processing health information, information about criminal convictions, etc., you would still need to appoint a representative. The representative will have to be able to communicate with you on a very short term. So if there is anything happening in the European Union regarding the processing of your personal data, the representative is your first person to go to, and your representative should be able to communicate with you, for example, when there is a data breach and you need to decide on what to do. If the authorities have any questions, or if a data subject has any questions, they will first address your representative, most likely, and your representative will have to be able to communicate with you on what to do or how to react. So this is an important step. I think we should move on to the Data Protection Authority, Data Protection Officer. Henrik will take it from here again.
Okay. Well, thank you, Martin. Now, under the present Personal Data Directive, it is already foreseen that the appointments of an official within your company to deal with these data protection matters, a data protection officer. The GDPR states that appointing such a data protection officer is actually mandatory under certain circumstances. It could be good to know, I think most people listening to this webinar are not from a EU public authority, but it could be good to know that EU public authorities will be required to appoint a data protection officer. This could often be a useful point of contact for companies and organizations dealing with a public authority, that they can expect to find a data protection officer there as a contact person. But for a private company, they will be required to appoint a data protection officer in those cases where the core activity of the company, the controller or the processor, consists of processing operations that require regular and systematic monitoring of data subjects on a large scale. So when you're actually not just what I should call run-of-the-mill processing, but you're involved in systematic monitoring and on a large scale, you will be required to appoint a data protection officer. And also in those cases where the core activity of your company consists of processing on a large scale data of these what we call the special categories of data. And another way of framing this is to say that when you're processing on a large scale, particularly sensitive data, and this is sensitive data in the same set of data as in the present Personal Data Directive, where matters regarding health, for example, or religion, or membership of trade unions, or matters related to sex, for example, things that are obvious to most people would be of a sensitive nature. When your core activity consists of processing such data, you will be required to appoint a data protection officer. Now, I would, in many cases, recommend organizations to appoint a data protection officer, even if it's not strictly mandatory, because it is a very useful function, considering that there are a great deal of detailed regulations that need to be complied with. They need not only be complied, you have to be able to demonstrate that you comply with them. And so whether the person has the official title of being a data protection officer, it is a very useful function. And there's no there's no official certification or educational diploma required, but you do need to be able to demonstrate that you're a data protection officer, at least in those cases where appointing one is mandatory, that this is a person who has expert knowledge of the law and practices. You need to be designated on the basis of professional qualities. Now, it could be a staff member, it could be an in-house person, or it could be an independent service contractor like a lawyer or an accountant or other service provider. You may find that it's often not cost effective to have an outside data protection officer, but again, it depends on how you set up the role of this officer, especially in these cases when it's not a mandatory requirement. Then it could be set up, the advice provided by the data protection officer in a way to be more cost efficient. But it is necessary that the data protection officer, in the cases where an appointment is mandatory, that they have to be able to be, you have to demonstrate that they are independent. They can't be fired at will, for example, when should they have suggestions or opinions about how the processing is to be carried out in a way that the present management of the company may not share or find irksome. Also, data protection officers are required, the mandatory ones, not to have a inherent conflict of interest. So here, for example, could be a case where an outside counsel, who is also the counsel to the company, might enter into a conflict of interest if, on the one hand, the outside counsel is expected to look after the best interest of the company as such. But if this counsel is also a data protection officer, the officer has to be focused on the data protection matters in a narrow sense, rather than the interest of the company at large. So it requires some thinking of who to appoint as a data protection officer. It has been my experience in my practice that companies have often found it difficult to get a staff member or an employee to accept this role because it's been seen as overwhelming. It can be useful to remember and to inform the potential nominee that there's no personal liability for a data protection officer. But so the task these data protection officers are to do is, of course, to act as the ambassador for data protection within the company, to inform and advise management and staff, and to monitor compliance with the regulatory. It is also the person who will be on point dealing with the supervisory authority, the national data protection authorities, if and when they come knocking, or perhaps more probably there'll be a regular routine sort of mass contact where they are required to respond to surveys and such. But on the whole, this is a quite useful function, particularly now with the new framework. So at least in my personal view, I would advise most companies who are not who have any kind of any kind of significance to appoint a data protection officer. Next slide, over to Marta.
Okay, on to the record of processing activities. The GDPR has a strong foundation of being able to demonstrate that you comply with the law. So accountability is a big thing, and transparency is a big thing. And the responsibility of being able to show that you comply with the law is with you. And the GDPR has an article in which it mandates certain companies to hold a record of processing activities. Based on the general idea of being able to demonstrate compliancy, a record of processing activities would be recommended for everyone, even if it is not mandatory. But it is mandatory in any way for controllers or processors with more than 250 employees. And if your processing is not occasional, it is also mandatory even if you have less than 250 employees. I think not many companies would have processing activities that are not occasional. So I think 99% of the companies would have to have a record of processing activities, if only it is because the processing is not occasional. So if you have a record of those processing activities, it needs to include who you are, so your name and your contact, the contact of your representative and your DPO. What are your purposes of processing, and the description of your data subject, so whose personal data are you processing? Are you sending it to other recipients? And are you transferring it to non-EU countries? These are important points to include Also, the time limits for erasure are important to include, so you will have to have thought about how long am I going to save this information and how long do I need it. Also, to conclude, you need to have a description of the technical and organizational security measures you've taken to secure the personal data. These are the bare minimum requirements based on the GDPR, but I would recommend every organization who processes personal data to make an inventory of all the personal data that is being processed, where it is being processed, and what the legal bases are of the processing. Because you will find that a lot of the personal data that you're processing is actually not even allowed to be processed. Also, lots of organizations most likely have a lot of old information that they don't necessarily need anymore and that could be deleted. This is, as far as I'm concerned, the starting point. Make an inventory and document everything you do. Henrik?
Yes, thank you, Marta. Yes, this is, I mean, the bullet, the rubric or headline for this slide was a record of processing activities. But yes, table to records that you have to know what you're actually doing. So the review of to carry out internal audit of your processing is incredibly important. Moving on to the next slide about consent. There are, as Marta has been mentioning, several alternative legal bases on which to carry out your processing of personal data. You are required, of course, under the EU data protection regulations to have a recognized legal basis for your processing. One of the most important such legal bases is consent, where you have the data subject's consent to the processing. Now, this has been amended or reviewed under the GDPR. Insofar as your organization's processing is based on consent, you would need to review if this consent still fulfills the requirements on GDPR. One good example, for example, of a change in the new regime is that under the present common practice, at least, is that organization will collect consent from data subjects within the course of entering into some kind of agreement or getting having a dialogue or communication with the data subject and discussing terms and conditions. And one paragraph might deal with consent in that context. Now, the GDPR has set a requirement that any collection of gathering consent within this kind of dialogue has to be clearly distinguishable from the other terms and conditions being discussed with the data subject. So this, one common practice evolving is to have a separate, explicit sort of tick box, for example, where the data subject makes some kind of mark or otherwise makes sure to express the consent in a form that can be documented and stored. And that is really to be recommended. But at the very least, you have to be able to show that you have been presenting the consent process in an unmistakably distinguished manner. As has been already been the case before, consent continues to have to be informed, but the GDPR makes it more clear by explicitly stating that the information about the processing being carried out, which lies as the basis for getting the consent, this information has to be easy to understand and presented in a form that the data subject can actually relate to. It has to be pedagogical. And this has also been, to my mind, a long-established, less than perfect practice by many business organizations, that the information about the processing presented to the data subject has been set in terms quite difficult to grasp for an average data subject. And this has never been a good practice, and now it is will clearly not comply with the requirements of the GDPR. So most organizations are advised to review the form of information they present, how the content has been set out, and then if they actually fulfill the requirement of being easy to understand. One further new aspect to consent is when dealing with minors or underage people who are not of regular, so normal age to enter into normal contracts or have the full rights of an adult. The GDPR has set a explicit bar of the age 16 where organizations may rely on these individuals' consent, at least as regards information society services provided online. Here again, the EU and the GDPR has left a level of dependence for individual member states to set another age limit as far as not going below the age of 13 for information society services. So those companies providing services in the EU to underage people will still, and especially if you want to provide them to someone who's younger than 16, you will need to do a country-by-country survey. Finally, one interesting matter where the regulation in GDPR about consent interacts with other regulations is when it comes to the use of cookies. We have today the e-privacy directive, the European Union part of the European Union Electronic Communications Code that is now being rewritten and merged into a unified code. But outside of the Electronic Communications Code, we will probably have an e-privacy regulation that is now being negotiated between the legislative bodies. It remains to see exactly what it will look like, but it seems very likely that the present, or we can count on that the present regulations of requiring consent to cookies, and this means that you can't rely on other possible legal bases, such as the weighing of interest. To set a cookie, you have to provide informed consent. Now, this has been quite a matter of discussion within the member states on how this consent should be gathered. We have a range of levels of stringency here, where some jurisdictions, as we will hear from the Netherlands, have set quite a high bar on how someone who places a cookie can be able to demonstrate they have a consent. In other jurisdictions, such as where I work in Sweden, there are a recent recommendation from the supervisory authority that web browser settings will be sufficient. This is again under the present regime, so we'll see what happens with both the privacy regulation and of course the GDPR comes into force. I know this is a matter that Marta has experience of from the Netherlands, so we'd like to, if I may pass over the microphone to you, you could tell us about how you've been working with tracking cookies, particularly in the Netherlands.
Of course, insofar as you are interested, but the Netherlands knows the Telecommunications Act, which requires for cookie placing that you have consent and that you inform the web users of the placing of cookies. And for the definition of the term consent in the Telecommunications Act, it actually refers to the Data Protection Act that currently exists. And the current Data Protection Act allows implied consent. So as far as we're concerned, until May 2018, implied consent will be okay as far as cookies go. But once the GDPR enters into force, of course, implied consent will no longer be sufficient. You'll have to have explicit consent. And as long as the Telecommunications Act refers to the Data Protection Act or the GDPR insofar as the definition of the term of consent goes, the consent will also have to be explicit. But of course, that is until the e-privacy regulation enters into force, and then things might change by then. But this means that you will no longer be allowed to use an opt-out option, and you will have to use an opt-in option. And consent is your basis when using tracking cookies. But in most cases, for example, if you have a web shop offering products to the European Union member states, your legal basis for processing that data will most likely be the execution of a contract and not consent. So in my opinion, consent is kind of overrated in so far that most companies think that as long as they have consent that they are okay. But it's important to realize that consent can also be withdrawn at any time, and that you will no longer have a basis for processing the data. So moving on to the processor agreements. I'm not quite sure how many of you already know the difference between a controller and a processor, because it has been a subject during the first webinar. But in short, the controller is the person who decides the goals for processing the data and also the means of how to process the data. Basically, the controller is the person or the organization who decides what happens with the data. If the processing of data is being carried out by someone else on behalf of that controller, and this is the case when you have online software system, cloud service providers, etc., then that third party processing on your behalf is the processor. And you have to have a contract with that processor. And the current the Data Protection Act, and based on the directive, has that obligation. But the difference is that the GDPR actually has content requirements regarding that privacy contract with your processor. The GDPR requires that you agree that the processor will only process data if you instruct him to do so. You need to have agreements on how to act when there is a data breach. The processor will need to be able to allow data subjects to exercise their rights, and so on and so forth. Security is the main thing because the processor is processing data that you are responsible for, which means that you need to have agreements with the processor in which you have some strict security measures that he needs to comply to. What those measures are exactly, it depends on the sensitivity of the data, obviously, and one of the last slides will be about the security. But it's important to know that when there is a data breach, the authorities will knock on your door as a controller and not as a processor. So you will have to be able to receive all the information from the processor that you need to do a data breach notification or to inform your data subjects on their processing, etc. It'll also function as a tool to demonstrate your compliance with the GDPR. Moving on, Henrik, the Data Protection Impact Assessment.
Okay, thank you, Marta. Yes, another new gift in the GDPR is a mandatory requirement, under some circumstances at least, to carry out data protection impact assessments. These assessments will have to be formalized in documentation in circumstances where the processing is likely to result in a higher risk to what the GDPR calls the rights and freedoms of natural persons. So there is some elaboration on when this comes into play. When is there a high risk to rights and freedoms? And one particular such case is in such processing that involves systematic and extensive evaluation of personal aspects, where you carry out automatic processing, such as profiling, and where you base your decisions on this automatic precision, where these decisions produce legal effects. Now, common examples of that is screening loan applicants or screening job applicants, for example, through automatic processing. That kind of processing will trigger a data protection impact assessment. Another kind of processing to require or to trigger a requirement for the impact assessment is when you process on a large scale sensitive categories of data, or actually, well, special categories. But what we mean to say are these sensitive kind of data that we have discussed already, such as ones relating to health, for example. Another kind of activity that would trigger an impact assessment requirement is when carrying out a systematic monitoring of publicly accessible areas on a large scale. And here, it doesn't have to be, for example, CCTV monitoring or like camera monitoring. There are all kinds of very useful and interesting and legitimate monitoring going on of, for example, monitoring movement of cell phones, if you can pick up Bluetooth or other signaling coming from portable devices to plot how streams are moving. I've been involved with, for example, engineers have been measuring the flow of vehicle traffic through electronic signals to see how you can systemize traffic and road planning. Now, this kind of monitoring will sometimes reach the level of processing of personal data, depending on what kind of signaling you're picking up. And this kind of activities can trigger an impact assessment requirement. There is an opportunity that the GDPR invites, or a requirement even, to consult with the relevant national supervisory authority in the cases where this processing indicates a high risk. So this is useful to remember that it may not just end with you having carried out the assessment. There may be a consultation requirement as well. Okay, that's what I want to say with this. Next, over to you, Martin.
Thank you. On to the right to be informed. Of course, you as a controller have the obligation to inform your data subjects on processing their personal data. It is nothing new except what is new under the GDPR, same as what's new under for the processor agreements, is that the GDPR has a list of information that you have to provide to the data subject before processing its data. And it's pretty hard to provide in that information if you have a lot of data subjects that you are processing data of. What you can do is use privacy policies on your website as a signature under your email, or add a link to web forms that people are inserting their data in. So make sure that it is that you have a privacy policy that you can easily show data subjects at the point or before the point where they insert their data for your processing. What you need to tell them is who you are, what your purpose and legal basis is for the processing, how you're protecting their data, how long you're storing it, what the rights are of the data subject. So you need to inform them of their rights so that they'll be able to exercise it if need be. You need to tell them if you're going to transfer their data to other parties or other countries, and if so, on what legal basis, and if you use automated decision making. So you probably noticed that this information is also something that you had to have recorded in your record of processing activities. You can recycle a lot of information if you write everything down and document everything once, and then just recycle it for different purposes. Of course, it requires some fine-tuning because your purpose and your legal basis for processing will not be the same for every type of processing, but it also means that you will have to have a few different privacy policies, or just one that includes every part of information. The data subjects have more than just this right, but I'm giving Henrik the floor to talk about the other rights of data subjects.
Thank you, Marcia. Yes, there's a long list of rights for data subjects, and many of these are not new compared to the present regulatory regime, but there are a few new ones. One new opportunity or requirement or burden, depending on your point of view, is the right for data subjects to data portability, where data subjects will have the right to get their personal data transferred to them or exported to them from a controller, where the data concerning the data subject has to be exported or transferred in a structured, commonly used and machine-readable format. So this will be of interest to very many organizations, and both who have the data and those who want to have the data. And Marta has in conversation mentioned several interesting examples, such as consumer playlists from a music platform such as Spotify, where the consumer may want to change his or her platform to another service provider, and may be able to use this right to data portability to get these playlists exported. I can imagine that records from an insurance company, if you had a long record with someone who collects quite a lot of data about you and uses it for you. It could be services perhaps not of purely medical fashion, but related to your health but may not be required by sort of patient rights regulations. But say if you've been working out using various devices and collecting quite a lot of information about your physical characteristics and accomplishments, this could be data that would be of interest to the data subject to have exported, and of interest to service providers to be able to have them imported and provide a better experience and better service to their customers. So the data portability right will be very interesting to see how this is going to be utilized in the economy going forward. More familiar rights is, of course, the right to access. The data subject has the right to find out what processing is being carried out by the controller about the data subject, if any. And there is a detailed list of what information to be presented upon request to the data subject. The data subject has, of course, a right to rectification, to have not just information being bad information taken out, but also to have information added where that is relevant to the processing and has been lacking. The data subject has the right to erasure, or also known as the right to be forgotten, where the controller must cease to continue processing under some circumstances the data subject's personal data. Now, this is not a blanket right. It's not unconditional. For example, it would have to be demonstrated that the controller continued processing of this personal data is not longer necessary. For example, for the carrying out of a contract, or insofar as the processing is necessary in order to comply with the legal obligation, then the data subject does not, that overrides the right of the data subject to have his or her data erased. There are also rights to restrict processing, again, limited and conditional, but still data have certain rights to object to processing. And an important right that we discussed, I think we touched upon when we talked about consent, is the right to withdraw such consent. And here, an important example is that in the course of an agreement, yes, it's a separate legal basis for process data in order to perform a contract with the data subject. But often, the provider who has entered into a contract with the data subject will collect various forms of other consent, consent to other processing from the data service that is not strictly required to fulfill the contract. Even if you are providing a service and you need some kinds of personal data, such as name and address, for example, in order to invoice, if nothing else. But the provider will often collect more information to provide added on services, or have the opportunity to build, to develop their services, or to provide marketing. So that will be the basis for processing this extra addition that's not necessary for the service itself, is often based on consent. And the data subjects will have the right to withdraw consent for that kind of processing that is not necessarily required to perform the service. So there's a long, sometimes challenging catalog of data subject rights that organizations who find themselves needing to comply with the GDPR will have to sit down and analyze to see that they can respect these rights. Marta, your turn to speak about data breach notification.
Yes, moving on. I think I'm going to speed up some parts because we have 15 minutes left and there are some questions trickling in. The data breach notification is probably a very important one because in case of a data breach, so if your data gets lost or it's subject to unlawful processing of data, meaning someone else has access to your data, unauthorized access. It could be anything from losing a laptop with personal data on it, or having a hack, a ransomware, you name it. If such a breach occurs and the data includes sensitive data, for example, medical information, pictures, username, passwords. I know LinkedIn, Twitter had some data breaches and leaked username, passwords. But if it includes sensitive data, meaning it could result in a risk to the rights and freedoms of natural persons, you will have to notify the supervisory authority within 72 hours of the data breach occurring. Now, it depends on what data subjects are affected by this breach to answer the question which supervisory authority should be notified. If you are a U.S. company and you are processing personal data of data subjects in the Netherlands, you would have to inform and notify the supervisory authorities in the Netherlands. If it involves more than just one country, you will have to inform more than one supervisory authority. Meaning you should probably consult the Mackrell privacy lawyers because we are represented in 60 different countries. But you should inform and see what the notification entails and in which country you need to do what. You need to have a first aid line, so in case you have a data breach, you know who to call and determine whether or not you should notify the authorities or the data subject. There's probably some differences between the member states because the Netherlands has introduced a notification requirement in 2016, and I've noticed that the Dutch authorities are quick to judge that. Except for notifying the authorities themselves, you also have to notify the data subject. And from Henrik, I understand that the Swedish authorities do not really require data subjects being notified as quickly as the Dutch authorities do. So there will have to be some judgments on that. One thing, you need to make sure you have a data breach policy in place so that you will know how to act whenever a data breach occurs, and make sure your representative knows how to act because initially your representative is probably the person who will need to coordinate anything that needs to happen. You have the obligation to document all personal data breaches, even if there is no notification requirement. So make sure your documentation is okay too. So in case the supervisory authority comes to check up on you, you will be able to demonstrate your compliancy. moving on to the privacy policy.
Yeah, thank you, Marta. I would like to clarify, I maybe I gave the wrong impression to Marta when we talked about data breach notifications in various jurisdictions, because yes, there have been examples where the Swedish authorities have required, under the present electronic communications regulations, where there are a breach notification requirement, that they have sanctioned telecom operators who have failed to notify data subjects on individual breach matters. But these are really the exceptions, because the operators have been incredibly reluctant to issue any notifications. And there is, according to published reports, there were probably around 50 breach notifications done by operators to the supervisory authority in the last year. But of these 50, it appears that very few, if any, were deemed by the authority to constitute of a nature to constitute a high risk to the rights and freedoms of individuals. So it'll be, I think that'll be a matter that the various national authorities will have to align themselves eventually to come at a reasonably harmonized level of when, at what point is a breach of a nature that needs to be notified to the data subject and not just to the supervisory authority. But moving on to the privacy policy matter, where I was passed the baton. This is nothing new in the GDPR as in itself. Privacy policies have long been a staple of professional organizations and the controllers of personal data. But we do strongly recommend organizations to review their privacy policies, because there are it's been commonly known, for example, that business models and technology develops over time, and so the processing changes and the requirements change. But it's not always that the policies are being monitored and updated. So we really, as a matter of routine, suggest that these privacies be reviewed. And one explicit reason to do so is that it is clearly stated now in GDPR in connection with the principles relating to the processing of personal data, that the controller must be able to demonstrate compliance. So you need not only comply, you need to be able to demonstrate that you comply. So we strongly recommend reviewing your privacy policy. Moving on to the next point about international and particularly EU-US data transfers. Yeah, thanks for the new slide. This is also nothing new compared to the previous regime. What is new is that a common legal basis on which many operators, many controllers have based their transfer of data from the EU to the US was doing so under the so-called the safe harbor regulatory framework. Now, as you will probably all be aware, this safe harbor framework was struck down, shall we say, by the Court of the European Union as seen as inadequate, and that the EU Commission had overstepped its authority in that particular case. And so the safe harbor has been replaced by the new framework known as the Privacy Shield framework. Now this is really in relation to the GDPR, an adequacy decision where the European Commission has found the protection of personal data adequate insofar as the transfer to the US under this Privacy Shield framework. This framework is administered in the US by the Department of Commerce. There's a mirror framework for transfer from data from Switzerland to the US with a very similar details. It's a voluntary self-certification scheme, quite a lot of organizations have latched on to formerly the safe harbor, now the privacy shield. But I mean, it's obvious from looking at the list that far from all of U.S. organizations that process data derived from the EU has utilized the safe harbor or privacy shield framework. It does require quite a lot of administration. I would invite you to go to the www.privacyshield.gov site to see the more detailed requirements of this. But of course, there are alternatives to using the privacy shield framework for transfer of data to the U.S. from the EU. One such is commonly used is to utilize the standard data protection clauses that have been formulated by the EU Commission and published in the official journal, where companies can copy into these contractual clauses that will set down obligations on how this data is going to be processed and the rights of EU citizens safeguarded. And besides these contractual clauses, there is something known as binding corporate rules that have been carried over from the Personal Data Directive into the new GDPR. Now, these binding corporate rules is quite a chapter in itself, and it's a quite elaborate process on adopting these corporate rules, and they need the approval of have to be inspected and approved by a national data protection authority. And so only the biggest companies are typically interested in this. But it is a matter of some interest, and it could be that you are dealing with a company who has adopted binding corporate rules. So it's good to know that they exist. And finally, of course, there are other, what is known in the GDPR, specific situations that will provide a legal basis for transfer of data to the United States. And one such, what under the headline of specific situation, is when the organization has the consent of the data subject involved. It's quite common for organizations who envisage transferring data to the U.S. is to, when they have the opportunity to collect the consent of the data subject to provide. And another well-known legal basis for the transfer, just as it is for processing data at all, will also cover the transfer is when the transfer is necessary for the performance of a contract with the data subject, and not just the contract itself, but the pre-contractual measures that could something be required to be able to enter into a contract. Sometimes, under certain circumstances, the contracts are concluded in the interest of the data subject. It can also qualify as a legal basis, but here are further conditions apply. Well, we're running a little bit short of time here, so we're going to move on to the final slide we wanted to discuss before possibly taking questions, and that is about security, where the GDPR makes explicit requirements on the processors and controllers of personal data to implement appropriate technological and organizational measures to ensure a level of security appropriate to the risk involved. The measures involved, of course, when we discuss appropriate, one measure is the cost, and it's soothing to know that you're not required to have most expensive measures possible for data that is not perhaps of such a sensitive matter, or the risk is not so great. So the costs should be proportionate to the risk. Some examples of measures that can take is to encrypt data to have it more secure when being stored against illicit use within the organization or if exposed to hacking. But of more common, more practical use is perhaps to pseudonymize information, use pseudonyms. So instead of having the actual names of data subjects being used, they can be given a pseudonym, so it would not be so obvious who the data subject is. I think we're running out of time here, so I'll discuss the regular statement of backups and how your security measures should be tested, assessed, and evaluated. But it's important to know that the GDPR sets concrete and explicit requirements on security. So over to our moderator, Sean. I think we may have some questions from the audience that we should try to address.
Yes, Marta, would you like to? Okay, there you go.
There I am. I saw a few questions that I think I should quickly touch upon. One of which is, does a controller have a data breach notification requirement if the breach occurs at the processor level? The main thing is that the controller is responsible for the processing of personal data. If anything occurs at the processor level, it is still the controller who needs to notify the authorities of the data breach. And the controller is also the one who will get a fine if something is wrong. So the processor is simply the person who is executing the processing, but under the responsibility of the controller, which is why it's so important to have a processor agreement in which you agree on cases such as liability, because of course you can deviate from the GDPR regulation by contract and decide that if there is a fine from the authorities that the processor will have to carry it. But of course not many processors will agree. But it is also why it is so important to have security measures included in that contract. Last slide, does the security program need to be in writing?
Well,
Sean,
if I may say so that, well, Henrik here, if I may say that, I remind that we've been discussing the requirement to carry records of processing, and we've been discussing the accountability requirements that you must be able to enable, the controller must be able to demonstrate compliance. I would say that there's not an explicit, doesn't say in the GDPR particularly about security that needs to be written, but it follows from the accountability principle that it's strongly advised to document what security measures you'll be taking. And yeah, so I hope that answers the question. Sean, our moderator, are there more questions or have you run out of time?
Marta?
Yeah, sorry.
Yes, one of you posted this question. Are you going to address it?
Yes, I am. I saw two questions that could be answered. Sean, I'm just muting you. The supervisory authority is different in each member state. So each member state has its own supervisory authority. And if you are a U.S. company, there is no supervisory authority in the USA regarding the GDPR. You would have to communicate with the supervisory authority in the member state itself. And I'm not aware of a list of all authorities in each country. I know who the authority in the Netherlands is, but I would not know who it is in Sweden.
I have a clear recollection that the European Commission has a page on its website that lists all the national data protection authorities. So there is an authorized list. I don't have the link in my head, unfortunately, but there's a quite good and comprehensive information page on the European Commission website about data protection, and it will list the national data protection authorities.
Henrik, there's a question for you here.
Privacy Shield. We have a question asking, among Privacy Shield, binding contract rules, contract clauses, which takes the least time? I would absolutely say the contractual clauses take the least time. as long as you can actually comply with them. You'll have to review the Commission's adopted contractual clauses. They have to be taken as they are. You can't amend them. You have to copy and paste them into your contract, and you will also have to be able to comply with them. But they're not unreasonable. So in most cases, I would definitely, when feasible, when you have someone to enter a contract with, for example, I would recommend those. Sometimes there's no one to enter into the contract with, and then the privacy shield may be a better alternative. Binding corporate rules, I again would not recommend other than for like global huge companies.
There was a question about
cookies.
Mm-hmm. There was a question
Yes?
about cookie opt-in and if you would have to record their name or other contact details for you to prove if they have opted in. The law says that you are not allowed, well, I mean the future, the GDPR, you will not be allowed to use cookies unless you have received a specific consent act. So the cookies cannot be activated until someone presses the button that says opt-in or I agree or any other active act of consent. So that is how you would make sure that only those who have opted in would be confronted with the cookies.
Yes, but you wouldn't collect the actual names of these users in most cases. I expect. I mean, you connect the opt-ins to a particular browser that you can identify.
I think these are the last questions. There are two questions about the DPO. Does it need to be a EU citizen?
I'm not aware of any such requirements. How about you, Marta?
Neither am I. The requirement is that the DPO needs to have the legal knowledge to act and function as a DPO. So it doesn't necessarily have to be an EU citizen. I received another question on the, let's see, on the DPO. If it is outsourced by EU expert, does the DPO person need any work permit to the USA? I think the visa requirements is not something that is regulated by the GDPR. I'm not sure I actually understand the question well either.
No, I think this question has confused different regulatory regimes. The EU supervisory authorities are not concerned with American work or immigration services.
I saw a question popping in about the cookies, but I don't see it anymore.
Yeah, the site is not serving up any more questions to me either.
Okay, Sean, I think we're done here.
Okay, with that, let me say if you are interested in attending webinar 3, and we certainly hope that you are, or going back and viewing webinar 1 that is available for viewing as this one will be, please email gdpr@hoagfenton.com. And with that, I would like to thank our speakers, Marta and Henrik, for sharing their time and their expertise on the GDPR today. I also want to thank Mackrell International and all of our colleagues in the Privacy and Data Security Group who are supporting this 3-part webinar series. And who knows, maybe we'll add a couple of more webinars to this as we go, so stay tuned. But lastly, I really want to thank Stephanie Sparks, who has taken the laboring oar on getting this webinar series organized and pushing us all to our deadlines, and thank Hoag Fenton Law Firm for providing the webinar platform. That is it. Thank you very much for attending.
Okay, I'm signing off here too now. So thank you, Sean and Marta.